Hello, my name's Emma Leavesley and I'm a family solicitor at Parfitt Cresswell. I'm going to talk to you about the unmarried family. Quite often people refer to common law marriages. They assume that once they've been living with their partners for a number of years, they gain the same legal rights and benefits as a married couple, and they consider themselves to have a common law marriage. Unfortunately, common law marriages are a myth. If you're living with your partner, no matter how long you've been together, you're not considered to be married in any way by the law. If you and your partner decide to separate, there's not any specific legislation which has been drafted for the benefit of unmarried couples. The Law Commission has reported to the government about the matter, but the government's decided not to pursue a change in the law for better protection for cohabitees, despite the legal profession supporting this. This means that as lawyers we have to rely on an assortment of different legislation, like the Law of Property Acts and Trust and Land and Appointment of Trustees Act, and also the Children Act to provide legal remedies for unmarried couples. If you and your partner are not married, then it could affect your rights to property, children and inheritance, so it is very important to seek legal advice if you are separating or contemplating separation. If you are cohabiting in a property with your partner, which one of you or both of you owns, then upon separation you will need to establish who has rights to the property. This will depend on who actually owns the property and what financial contributions have been made by the individuals, and also what shares they intended to have in that property. For example, if a property is owned by the couple in joint names, there's a legal presumption that they will own that property in equal shares, irrespective of the financial contributions they've made to the property. Therefore, initially it would be expected that the property will be sold, or one person will buy out the other's share, or for half the value of the equity in the house. This will be the presumption unless it can be demonstrated that it was intended that one person should be entitled to a greater share of that property. This means that if one party has paid the deposit and made all of the mortgage payments on the property since it was bought, when they separate there's a legal expectation that the other person is entitled to half the equity in the house if it's in joint names. If it was intended when the property was purchased jointly for one person to own more than the other, then this should have been documented by a deed of trust, which will set out exactly what percentage shares they each own in the house. This is a legal document and will be irrefutable. If the property is owned in the name of one of the partners and not the other, the legal presumption is that the owner is entitled to 100% of the equity in the property. If the other partner has made significant financial contributions to that property, including payments towards the purchase price, deposits, or even mortgage payments or significant financial payments towards renovations over and above decorating, they could prove that they're entitled to a share of the equity. This is called a constructive trust. The burden is on the non-owner to prove that they have a financial interest in the property, and the burden is very onerous. They will have to provide bank statements, receipts, and if they've been together for many years, this may be impossible to prove. So for many couples who've been together for many years and one pays the bills, grosses, and the other pays the mortgage, they could find themselves without a claim in the property they've always lived in. As a last resort, they may be able to claim a remedy in proprietary estoppel, but they would have to prove they relied on the promise to their detriment that the property would be their home forever, or that they would have a certain interest in this property. It's very difficult to prove and very expensive. There are two ways of avoiding this. Firstly, a cohabitation agreement. The couple could enter into a cohabitation agreement when they buy the property or at a later date. This is a document which is prepared by a lawyer and will detail what contributions will be to the property in terms of capital and income and what their respective financial shares in the property will be. It can go much further and detail who will pay the mortgage, what happens if one person makes a large monetary contribution towards the property, or what if one wants to buy the other one out and how it will be calculated. For example, it can be used to regulate how joint accounts will be used and divided on separation, payment of debts, ownership of vehicles, and how gifts are treated. There is still legal debate as to whether cohabitation agreements are strictly legal and enforceable, but there are evidence of the partner's intentions which can be used in evidence in any subsequent court proceedings, and they would be very influential as long as the parties had entered into the agreement freely, without duress, and had the benefit of legal advice. Another option is a deed of trust. When a couple buy a property jointly and they wish to own the property in unequal shares, a lawyer should prepare a deed of trust for them which sets out the details of the trust at the date of purchase. This will specifically set out the shares that each partner will own in the property and how the property will be divided should the parties separate and sell it. A deed of trust is different to a cohabitation agreement. A deed only sets out the terms of the trust between the joint owners of the property, and it is legally enforceable. A cohabitation agreement goes further and can regulate how they manage and own the property, as well as other general matters financially between them. Another important issue is about children. It's important for parents to know about parental responsibility. When parents are married, both by law, they obtain parental responsibility for their children. PR is a legal status, which means that parents have legally recognised rights and responsibilities, duties and powers and authorities towards a child of the family. It means you can make decisions about the child's education, consent to medical treatment or changing a child's name. However, if parents are not married, whilst the mother automatically has parental responsibility, a father does not. A father can only acquire parental responsibility in the following ways. Firstly, if he's named on the child's birth certificate with the mother's consent and the child was born after the 1st of December 2003. 2. The parents sign a parental responsibility agreement. Thirdly, in default of agreement, the court can make a parental responsibility order. Or fourthly, if the court makes a residence order in favour of the father, he will also get parental responsibility. Even if you and your partner are not separating, you should be aware that married partners do not have the same rights to inheritance as married couples. You should therefore ensure that you have a will in place so that your wishes are followed upon your death. If you need any further information, please do not hesitate to contact either us by email at family@parfittcresswell.com or call us on 01753 271 640.